Morning and good evening to our friends who are joining us from the Americas. We're talking today about the Adani Group indictment in a federal court in the United States of America. And we are going to essentially talk in terms of facts which are not in dispute and also the question of law. Because generally speaking, the Indian law and the people trained in the Indian law are not very well versed with what happens in the American judicial system when a judicial or a criminal indictment takes place before a federal judge, which also includes a jury. I had been following up the various Trump cases, the civil case in case of Donald Trump, as well as the federal indictments and the state of New York case of falsification of records and so on. So I had been able to pick up some threads and understand, at least on rudimentary basis, what the American system is like and how it works, and to try and place it in an analogous context with the Indian system. But first of all, it was really a bombshell for the Indian stock markets and also for the Indian political system. We are going to keep out of the politics because whether it is press, whether it is the media, whether it is the social media, whatever they say or do is going to be, practically speaking, irrelevant and redundant from the administration of justice system in America. So all the noise which is being generated within the parliament, outside the parliament, in the media, the cacophony of the TV studios, those, in my opinion, is not going to help either positively or negatively. As far as the Adani Group chairperson is concerned, he has not been seen in public since the news of indictment was broken and by the Department of Justice in an official press note, and then covered worldwide by the mainstream media, social media, including in India. And a parallel kind of show cause notice or indictment by the Securities and Exchange Commission of the United States of America, which, broadly speaking, is coterminous with our SEBI, or the Security and Exchange Board of India. So now the story which the US prosecutors are telling the court. First of all, this is not equivalent to an FIR. It is not the beginning of the investigation. Rather, for people who understand the Indian criminal jurisprudence system, this goes beyond the FIR and goes to the stage where a kind of a challan is placed and presented before the jurisdictional judicial court, and then the court frames charges. So this investigation by the Federal Bureau of Investigation had been going on. There had been search warrants, and the premises of the nephew of Mr. Adani Sr., that is Sagar Adani, in USA was searched, and some electronic equipment was seized, and obviously evidence was culled out of it. And what they present is a comprehensive indictment. It's like a challan, it's like a charge sheet, which is then unsealed before the federal court. And in this case, the federal court happens to be in New York, in Brooklyn, to be more specific. But it is a federal court. That means it is a court of the central government, of the federal government of USA, and the Department of Justice is the one who's steering it. The public prosecutor or the district attorney who's going to appear is an employee, an agent of the federal government of the United States of America. So now, before we get into the core and pith of the charges, and I'm sure various questions have also been raised in media that the allegations of corruption, if any, are on the Indian soil, qua Indian officials and politicians, and therefore what jurisdiction in terms of extraterritorial terms does any instrumentality of the federal government of America have to delve into the same, investigate the same, much less frame charges and bring to trial the leading industrialist who has been making investments, generating employment, so on and so forth. not only in India, but also abroad. So now, what happens when the indictment is unsealed? The person against whom the indictment is, four or five people, the two Adanis and the other people, executives of the sister concerns or the concerns who were doing business with them, they are summoned to appear before the court. And in some cases, the warrants of arrest could also be issued. Essentially, summons and warrants are nothing but a procedure and instrumentality of law to ensure the presence of the accused or the defendant, as they call it in American terms. We use the term accused in India and defendant for the purpose of civil litigation. But either way, they are supposed to appear before the judge. At that stage, the entire packet, in terms of the evidence, the witnesses, what statement has been there, whatever they are going to rely upon, the entire packet is given to all the accused, and they have option number one or two and no other option. Either you plead guilty or you plead not guilty. Now, of course, if you plead guilty, then it goes straight away to the stage of sentencing, which may take a couple of months, or there could be a plea bargaining. We'll come to that later, in which case you had a kind of a behind the scene agreement with the prosecution, so that while you plead guilty, you may be let off with a milder sentence, or you may even avoid jail time, but there could be very stiff financial fines. Now, once you plead not guilty, then the entire show of the prosecution begins. They bring in their witnesses, they bring in the documents, they have the examination in chief on oath, and obviously the defendants and the accused, they have the right to cross examine them. So this goes on, and ultimately, as they say, the prosecution finally rests its case. So all the documents which were there in the docket, all the witnesses, cross-examination, proving, absolutely goes through a process which is pretty fast. I mean, it is not as if one date to the next date is going to be 2 months. Here, once the trial begins, it's pretty much day to day, except for a couple of days when the judge may be away and so on. And at that time, the jury is sitting there. Jury are silent spectators. They are supposed to have their ears and eyes open but mouth shut. They are not supposed to be directly addressing any witness or the accused or the defendant or the prosecutors. They may sometimes pass a quiet note to the judge for some clarification, but that is more of an exception. And thereafter, you have the defense coming out with its entire evidence, whatever you want to say on a question of law, question of fact. And obviously, the prosecution has the right to cross examine those witnesses which you bring forth. As far as the accused is concerned, now it's very clear, like even in the Indian system and the American system, you have the right to maintain your silence, and no adverse inference can be drawn against you. But should you put yourself onto the witness box as the accused, then you are on oath, and you have to tell the truth, the whole truth, and nothing but the truth. Whereas in the Indian, the old CRPC, I think it was 303 CRPC, one had a different system. You accused can go, and in fact, it is incumbent upon the judge or the magistrate to summon the accused and generally ask him. And in the Indian system, oath is not administered. Therefore, even if you're lying through your teeth in the witness box defending yourself, nothing happens to you. On the other hand, if the accused does put himself or herself in the witness box in the system of United States, you will be subjected to some of the most rigorous cross-examination. And your primary offense may not be much, but if you are found lying on oath, the penalty and punishment and sentencing for perjury is far, far more stiff. It's not like in India, you can, say anything on affidavit and perhaps nothing may happen to you. And the offense of perjury is here also. But in this case, sometimes the original offense may be not so heinous, but if you are lying on oath in the court, or even if you have lied to the investigating agency while the investigation was on, even that is supposed to be a very heinous offense. So, that of course, having said that, this can begin only if the accused is present in the court. Normally speaking, there could be exceptions. Normally speaking, the trial cannot begin unless all the accused are there. And depending on the facts and circumstances of the case, you would have a common trial. You could have two, three, five defendants, joint trial. But very much possible some of the people who perhaps are either not responsible for very heinous acts of crime, they may want a separate trial. And it is also possible in the American system that in the Indian system also, where you turn the approver. So it could also happen that what is an accused and a co-defendant at this stage may start cooperating with the prosecution and may be let off with a much, much lighter sentence or even probation of good conduct, as they say, which means you avoid jail time. So once the trial is over, then the jurors and the jury withdraws and they discuss. It can be 2 hours, 24 hours, 48 hours, 20 days continuously, and they have no connection whatsoever with the outer world. Yes, a short note can come and go as to any clarification they want from the judge, but within it is literally a black box. And while the jury is deliberating, the accused have to be there, and ultimately the jury on the various charges, there could be 1, 2, 3, 4, 7 charges, would return a verdict simply either guilty or not guilty, guilty or not guilty. And they are not supposed to record any reasons, no nothing, and ultimately the case, the trial ends there with a conviction on so many counts, the heinous ones, not non-heinous ones. There are misdemeanors and there are various other type of offenses. That's a matter of detail. And after that, once you've been pronounced, let's say, guilty, President Trump was pronounced guilty in the business records falsification case. If you think you're a flight risk or you don't have roots in America, you could be sent to the jail forthwith, awaiting sentencing, or you could be let off with, a stiff bond, or with your passport being deposited, or even house confinement and so on. And then the sentencing takes place after a longish time, 2, 3, 4 months, and depending on the guidelines, depending upon the heinousness, your own act and conduct, and whether you are, genuinely sorry for your act, your age profile, your contribution to the society, and so on, the judge would then pronounce the sentence, which could be a prison term, could be a suspended sentence. That means you stay out of the jail, but you're under probation for good conduct, and so on. So that's the American system. And in the passing by, we also refer to the Security and Exchange Commission. They have said, well, this thing was wrong on your part. Now, those are essentially civil proceedings. No one is going to land up in jail when responding to the judicial proceeding before the Security and Exchange Commission of the United States of America. It's just like a SEBI. All they can do is impose huge fines. If they think you made a profit of $250 million, they may deem it fit to impose a civil fine of $1 billion. If certain people, your investors, have been defrauded, they may ask you to compensate them by even 10 times, and so on and so forth. But those are proceedings which are interconnected but independent. So therefore, you could get away from the Security and Exchange Commission by having a kind of a plea to say there was no wrongdoing, but we compensate our investors. Yes, but in case of the Department of Justice indictment before a federal court, you have to go through the trial unless you plead guilty. And at the end of the trial, the sentencing would take place. The appeals at the initial stage is exceedingly rare. It's like our quashing petition. This would take place only and only if, on the plain reading of the indictment documents, it transpires or the judge is convinced that no criminal offense in US is made out, then the case could be thrown out. But those cases are far and few. And once the indictment is unsealed in a federal court, generally the trial is the norm unless you plead guilty or you have a plea bargaining. Now, in theory, plea bargaining would be your defense lawyers and the prosecution sits and they say, hey, this is the deal now. If you ultimately go through the trial and are proven guilty, gentlemen, you could end up with 20 years on jail. So what's the deal? The deal is you pay $1 billion in fine and you have a jail term of 1 year and a suspended sentence of 3 years. And okay, they say 1 year is fine, but make it house confinement and so on. So that could be a plea bargaining, in which case, of course, the judge has to accept it. But in that case, the trial would not be necessary and the case would end there. Now, what people have been asking generally is the extradition. They say, all right, the defendant A, B, C, D are not within the territorial jurisdiction of the United States of America. They're abroad, they're in India, we don't know where they are they in Kenya? So then the Foreign Law Enforcement Office issues a warrant, and that warrant is, of course, to be executed through the Interpol, which effectively means that if there is a federal indictment and you're failing to appear before the court when summoned, then you have the Interpol warrant would effectively mean that your travel abroad is for all intents and purposes over. One has to confine oneself in the home country, which is India. Now, what is the procedure for extradition? India and America do have a treaty of extradition. The procedure is cumbersome. It has to be an offense in both the countries. So America is already convinced that it is an offense on our side, and whether paying illegal gratification and briberies to the various distribution companies and state governments as a part of the solar deal is an offense. Obviously, on the face of it, it is an offense under the Prevention of Corruption Act. But this extradition proceedings can be long and lingering because the person can then defend himself and bring about all the points which he has to make in his favor or not. Now, what people have been saying, and I had to do a bit of research on that also, what exactly was happening and what is the allegation. I'm using the word allegation, and by way of a disclaimer, once again, and even the Department of Justice documents say that unless a person is convicted, he is presumed to be innocent in the eyes of law. It's a universal principle and applies in this particular cases. So it is not even an insinuation on our part that either Mr. Adani, Gautam Adani, or his nephew, or any of the executives or the co-accused are guilty of any offense. But the facts which are being alleged by the Department of Justice are as under. They say, well, how did this thing unroll? And it unrolled like this, that Adani Group wanted to set up solar generation power, and rather there is Solar Energy Corporation of India, Government of India Corporation, wholly owned by Government of India, which is promoting the green energy. And not only promoting, then why should anyone set up if you can't sell that power? So it also enters into long-term power purchase agreements with the solar, and in turn, having tied up that, you set up the solar plant, you know that your solar power is going to be purchased by the Government of India enterprise at such and such price. And on that authority, and on that confidence and on that understanding, you execute a huge and one of the biggest solar plants in India. Of course, you got your own vendors who do the execution work, the company called Azure and so on. That's a matter of detail. So the Solar Energy Corporation of India in 2020, as per the Adani Group press note, they had proudly proclaimed that we won this tender, the world's biggest solar project. I think it was 12,000 megawatts of power to be generated, and well, and they set up with the assurance that the Solar Energy Corporation of India would be buying that. Now, incidentally, the Solar Energy Corporation of India is not a distribution company. And if the power is generated, where does that power go? Power cannot be stored. Like hydropower, it has to be consumed. It has to get onto the natural and the national grid. And bulk of the distribution is with the states. You have power generation by the NTPC and the NHPC, which is the Government of India entities, national thermal power, and so on, even nuclear power plants, so private sector and so on. But the distribution is either in the hands of the state government or in the hands of the some private companies and joint ventures and so on. So ultimately, even the Solar Energy Corporation of India has to sell that solar power to the states, and the states which have been named, generally I'm open to correction, is the residual Andhra Pradesh, Tamil Nadu, perhaps Chhattisgarh, Union Territory of Jammu Kashmir also figures in. So therefore, those state entities were not willing to purchase this power from the Solar Energy Corporation of India, which had a back-to-back agreement with the Adani Group, because they said, well, we are getting cheaper power from here and there and our own sources. Why should we buy your solar power? And they were exceedingly reluctant. And the allegation in the Department of Justice is that the Adani Group, with a view to facilitate the signing of agreement between the state distribution companies and the Government of India, entity called the Solar Energy Corporation of India, they kind of paid bribes or illegal gratification to smoothen the system out. And of course, there was a kind of a comfort factor for the state governments to, or their distribution companies to say, hey, we are not signing any agreement with the Adani Group, it's a private company. What if we are not floating a tender? We are, in any case, signing with Government of India. So where could there be any question of illegal gratification? And suddenly those companies and those distribution companies and power utilities of the various state governments, which were initially reluctant, we kind of agreed, to purchase the power, maybe at those rates, higher rates, some rates which were negotiated downwards. Fine. Now, if true, these facts, then these are obviously offenses under the Indian law. But the question which our media has been asking, what business does the United States of America have to kind of, initiate their own proceedings? How does America come in? Who's offended? Have we tried to bribe any American public servant? No. So their argument and stretching goes as under. What they say is that, okay, you guys were raising funds in the American market, whether individual investors or institutional investors, whether by way of bonds, which would mean essentially loans, or by way of equity or convertible debentures, whatever, you were getting money of the Indian markets, of the US markets, and in the various documents that you submit to the Security and Exchange Commission, equivalent to our SEBI, and you swear on oath that we have not paid or not going to pay any illegal gratification to anyone, and so on and so forth. But lo and behold, here our investigation has revealed that you paid an aggregate sum of dollars 256 million to public servants in India. They have thankfully not named. Maybe during the course of trial, those names will pop up if the trial does proceed. And they say that this $256 million is indirectly a loss of income of the American investors. So, A, you have lied that you paid And moreover, these are the profits of the venture which should have gone to our investors. So you have kind of defrauded the American investors by paying that money to Indian public servants. Had you not paid, perhaps this money would have flowed back into the pockets of the American investors. So that's how they say, and they have their own, global laws that once you are dealing in the American markets, you cannot be indulging into corporation corruption anywhere across the world. And should you do so, then you should not be doing business with America or with the American investors. And should you be doing so, you're exposing yourself to this prosecution. So there the matters stand. So the collateral damage which does happen in a case like this is very simple, that for all intents and purposes, I mean, apart from the fact that we have clearly said that it'll be very difficult for the persons indicted to be able to travel outside the country. That's one. The other thing is you're being able to raise funds from abroad, including America, including Europe, and all other entities aligned. I cannot say whether China or Russia would make investment under such circumstances where you are under a shadow of doubt in the Security and Exchange Commission or facing criminal charges. But as far as raising funds from the agencies and companies abroad in USA and Europe, the Western world, that practically would be over, not only for this particular entity, but I think the group as a whole, because once the confidence of the markets is lost, then no one is bothered whether it is same legal entity or a different legal entity. People will, to use the American phrase, not touch that paper with a barge pole. So we now are here. People are defending the Adani Group. Adani Group itself has denied. We have submitted and we reiterate as a disclaimer that person, unless he's convicted, he or she continues to be presumed to be innocent in the eyes of law. So be that as it may, it's very, very clear that this is an exceedingly tough situation. Talking here, having your lobbyist do X, Y, Z, or having a debate or a so-called expert saying that no, nothing, this will be thrown out on the first date, it does not make any offense, it does not make any logic. Those type of things will be absolutely irrelevant for the purposes of the judicial proceedings that go on. So having said that, it is quite clear that these are essentially going to be tough days, and we have to see that and wait for the things as to how they unfold. One question which had been said is, what about sir, the presidential pardon powers? Mr. Trump, the president-elect, is going to be in office in January. So what about the powers of presidential pardon? Interestingly, this is a federal case, the case of the government of United States, the central government or the federal government, and the president does have the power. Normally, it is exercised only after a person is convicted. And but I think there is nothing in law which prevents the president of United States of America from pardoning any person, irrespective of the stage. I think it can even be possible for indictment and so on. But President Trump, more than statesman and a diplomat, the president, he's a kind of a deal maker. He's a businessman and he means business. And should he do so? And I think, firstly, seeking presidential pardon would really be the last resort, which the Adani Group would be advised to do. But this is the last of the last resorts. In that event, I think President Trump would extract a very heavy price. I mean, price not in terms of dollars, but in terms of allowing the American companies to do business in India, Tesla to set up its manufacturing. India has consistently said that Tesla cars are not safe for the Indian roads, or Indian roads are not safe for Tesla cars either way, or the Starlinks network, which again Elon Musk owns. So those type of things are in the realm of conjectures and hypotheses. So we have to wind up with the remarks that this indictment is a serious business. It is not something can be brushed aside by saying that we hereby deny. It is not a Hindenburg report by a private person which can be junked to say that they were out to make money. You cannot even say it was political in the sense that the outgoing Democratic president or his administration has done this. Why should they do it? And some people were saying that the timing is such, the parliament is on, and so on. Those people are not bothered something or the other is happening throughout the world. They go about their business in their own way and pace. So those type of lame excuses are not going to help either the cause of the Adani Group or the state agencies. The major question whether a parallel CBA or ED investigation would commence or should commence, that's an open question. That is what the opposition has been demanding. And the popular thing for the opposition is to have a joint parliamentary committee. In my opinion, joint parliamentary committee only delays the proceedings because the JPC does not have the power to either convict anyone or to even impose a penny's worth of fine, much less send anyone to uh, prison or jail. So therefore, at the end of it, you would again be compelled to lodge an FIR. In case of Bofors, you started with the JPC and the CBI inquiry, and until the Bofors FIR was actually registered formally by the Central Bureau of Investigation, things did not proceed. Now, those are entirely different things. Whether they happen or not, I think is again irrelevant for the purposes of how the system and the trial is going to unfold. So, right now, we have to wait and see what view Mr. Gautam Adani, and of course, advised by the topmost lawyers from USA and India, would take. There would be background, maybe diplomatic channels open, but then judicial system in America and Department of Justice, they are kind of insulated from the executive, as we understand, and the due process is very strong and robust. And so, A, whether he chooses to join and present himself before the trial court, B, if not, extradition proceedings, and in any case, not joining these proceedings, two implications straight away. One is your ability to travel abroad, and C, secondly, of course, your ability to raise funds for the group companies. So these are the issues that we wanted this morning to address. I wanted to write an article in the KBS Chronicle, which I regularly do. It's free, the subscription, and you can drop in Twitter or DM me your email, and I could put it on the system. So the articles, whenever published, unassumably they get into your inbox. And of course, your email is not publicly revealed by the Substack newsletter. So, Senior Chartered Accountant Mr. Kailash Maheshwari has made some comments. It's not a question. So, if there are any questions, friends, on Twitter, if you could put real time, my ticker is on. One would try to answer that to the best of my ability. But we need to understand that it's not a case where he's going to cooperate with the agencies as such. So it is not as if we say, CBI is investigating, ED is calling me, I'm cooperating. Those investigation is over. Those day and time and stage is over. Now you're going to be in the court. Firstly, you keep mum, plead not guilty, and then The prosecution will bring its cards one by one from the docket of your your indictment, and you have to, of course, the right to cross-examine. And finally, when you put yourself, your defense, and finally, if you want, you can get into the witness box. The flip side is you would be on oath, and should you be caught lying on oath, the penalty and punishment for perjury in US is far more than some of the other offenses. So that is it. Button for the better from Brampton. Thanks, good coverage. Thank you very much. I'm glad that you were able to join. And needless to say that on whatever medium you are joining, whether it is YouTube or Twitter, or whether you are on Facebook, this video would be there. And if you think it could be of use to any person who you think would benefit from there, please do feel free to share. So, and if there are any other particular topic on which you would like me to talk about or discuss, we can do that. If there are any other comments, questions, we still have about 2-3 minutes as far my clock is concerned. Otherwise, we can then, call it a day. It's 10:38 a.m. Indian Standard Time, and one could imagine pretty late in the evening, at least on the East Coast. On the West Coast, it could be a more urbane time, should we say it. So thank you very much. And even if after this there are any questions, do please feel free to post them, and I would again try to answer them to the best of. So thanks for joining, and keep in touch, and good night, and have a good day ahead. Thank you.